This case involves the narrow issue of setting aside a default judgment that was entered against father.
Good morning. This is a simple motion to set aside filed by the father through testimony, and then the attached or not the affidavits, but the exhibits. It will clearly illustrate that not only was father trying to not get served, we had to file for a motion for subserve after 6 attempts, but we'll also illustrate directly that he had knowledge in June and August that he was served. He did not want to move forward with his legal proceeding, and that he was trying to get money to pay an attorney. And under the Craddock factors, notice and an ability to illustrate a meritorious defense, as well as show that this was not a cause of him just wanting to stick his head in the sand. And this evidence would clearly state that this was him just trying to avoid service, avoid this case. And the only reason he set this motion to set aside is he doesn't feel comfortable with the stipulations that the court entered in November. Thank you.
Thank you, counsel. Attorney Griffin, you may call your first witness.
Thank you, Your Honor. I'd call Fabian Alvarado.
All right, you may proceed.
Mr. Alvarado, could you tell the court whether or not you wanted to defend yourself in this case?
No, I did not.
You didn't want to defend yourself?
Oh, yes, I do want to defend myself.
Okay. Did you intentionally fail to answer? I mean, did you know that that Ms. Ashley Ayala had filed a lawsuit against you?
I had received something in the mail, but it wasn't like nothing to be served. It was like something like that it was being taken off of child support. I'm not sure what it was. I brought it to her, but I never received anything about being served.
Okay. Did you know that she was filing a lawsuit against you?
No.
I mean, well, did you know that she was taking action to file an action against you?
Other than that letter, no.
Okay. What did the letter say?
I'm trying to see if I still have it. It was something about it being dismissed or something like that.
Okay. When you were served, or when it is alleged that you were served, what was the method of you being served?
From what they allegedly left me?
Yes.
I'm not sure. They said that they left it like on the door, but I never got anything on a door.
Okay. So how did you find out that something had been left on the door?
I got it from Ashley, the paperwork that the trial was had already passed or whatever. It had already been finalized.
Okay. And what did you ask Ashley at that point?
Nothing. I don't really ask many two questions with her. I try to keep as less contact with her as I can.
So did you receive the final order that was signed on October 17th?
She gave it to me after the trial had already been finalized. Yeah.
Okay. And did she also give you the motion and the order for substituted service?
What is that?
Well, how did you find out that you had allegedly been served by somebody leaving something on your front porch?
I had went to another lawyer's office and they told me.
Okay. So was that the first time that you learned of that alleged service of process on you?
Yes.
Okay. If you had known that you had actually been served when that was placed on your porch, would you have filed an answer?
Objection, yes. Leading and compound.
Sustain, don't lead.
Can you tell the court whether or not you would have filed an answer if you had known you had been served?
Yes.
Okay. What did you do when you found out that an order had been entered against you?
Just started looking for lawyers.
Okay. And you hired my firm to file a motion to set aside the default judgment. Is that correct?
Yes. Yes.
Now, did you have any conversations with Ashley regarding child support and regarding custody of your kids prior to her entering or having the default entered against you?
No,
You didn't have any conversations with her at all?
no, me and her don't really communicate
Okay. Did you have
other
any?
than just to exchange the kids
Did you text with her at all?
on. I'm having trouble understanding what you're asking. I'm sorry.
Did you have any text communications with her from the time, like prior to the order being, prior to the default order being entered against you?
No,
Okay. Do you believe that the order that was entered against you is in the best interest of your children? Do you,
hard to say.
let me back that up. Do you think that you should have some rights
Oh yes, yes.
to
I think I should have more rights to my kids.
okay, the order that was entered against you, do you have, I mean, you've been appointed a joint managing conservator, is that correct?
Yes.
But do you have any of the key managing rights of a joint managing conservator?
No, I do not.
Okay. Do you have the right to make or have any say in the medical treatment of your children?
No, I do not.
Or for a non-emergency invasive medical procedures?
No, I do not.
What about educational decisions? Do you have any rights under this order?
No, I do not.
Do you have any rights to enroll the children in school?
No,
You have
I do not.
You have the right to make decisions concerning psychiatric and psychological treatment.
No, I do not.
Do you have any right to the early marriage or military enlistment of either of your children?
No, I do not.
Would you like to participate in making those decisions?
Yes, I would.
And would you be requesting that the court do that? If
Yes.
you were able to have an actual hearing on the merits of this case?
Yes, I do.
Okay. Are you currently employed?
Currently not.
Okay. And were you ordered to pay $800 plus in child support?
Yes, I was.
I'm sorry, $845 in monthly child support
Yes, I was.
and $379.46 in cash medical support.
Yes, I was.
Okay. And how much money are you making on a monthly basis?
Right now, very little. I do what I can to make what I can.
Do you believe that the child support amount is within the guidelines set out in the Texas Family Code?
No, I do not believe that.
Would you like the opportunity to present a defense of your case? In
Yes.
the event that in the event that the court sets aside this default order?
Yes.
Okay. Now you understand that. Well, let me ask you this. Explain to the court where it is alleged that you were served at the house where you reside.
They said that it was served to the front door or side door. I'm not sure which door, but it was served just to a door that I'm guessing I never got to see.
Did you ever find first of all, is that a door that is used?
No, it is not.
How do you enter the residence of that house?
I entered through the back.
Okay. Were you ever apprised of the fact that you had been served with the citation and petition in this case?
Say that one more time.
Did anyone ever tell you that you had been served with a petition?
No.
Okay. And did you ever find that on the front porch?
No, I did not.
Did anyone in your household tell you about any pleadings? that's
No,
been left at the front, on the front porch of your house?
no.
Now, you understand that Ashley incurred some fees and costs when she proved up this case back on October 17th, correct?
Yes.
And you are offering to pay those in the event that the court will grant this motion. Is that correct?
Yes.
Okay. Pass the witness.
All right. Attorney Pedicini?
Thank you, Your Honor. Mr. Alvarado, where do you live at?
I currently moved back to my parents' house.
And that's the 195 Castle Ridge or Castle Rock?
Yes.
And when did you move back in with your parents?
Probably a few months ago. I can't say when. Let's see. Because I was living with my sister for a little bit.
Okay. We're a few months ago. We're talking in the springtime, summertime.
I want to say like mid-October. I moved back here.
Okay. And why would anyone answer the door and say that you live there, though?
I was only here for whenever my kids were here. Like whenever my kids would come over, I would come and stay here with them when she would give me my kids for the weekend.
So, when was the last time you held a job, sir?
Last time I held a job, I used to drive CDL, but it wasn't going good, so I had to find other things to do. And now it's just been having trouble finding like
Were,
little side jobs to do.
were you employed in April of this year or last year?
Like, no.
Okay. And were you ever at your mom and dad's house during April?
Mm, Here and there.
Okay. Now, what is your phone number, sir?
My phone number is 469 437 1590.
All right. May I share my screen, Your Honor?
Yes.
Okay. And this, I believe, is marked as Mother's 1 or 2, and this is a text message between you and Mom. Is that correct, Mr. Alvarado?
It looks blurry. I can't see it.
Okay. You can't see it, Your Honor.
No, I'm on a phone.
Your Honor, can you?
I think you can zoom in.
Okay, we'll try this.
Yeah, there you go.
Okay. Can you see it now, sir?
Yes.
Okay. So that's your phone number at top where it says 469-437-1590, correct?
Uh-huh.
And this is in June of this year, correct?
Yes.
And you wrote down that, yeah, plus you'll be getting your child support pretty soon, apparently since I already got served. Is that correct?
Yes.
So you wrote a text message saying that I already got served in June to the mother of the child. Is that an accurate statement of what we're reading right now?
No, that's from that letter that I was talking about, the one that I got in the mail.
Oh, did you do any kind of research after you got that letter in the mail?
No, we don't, she didn't even know what it was either.
Okay. Now, the next email, if I may, can you look at this one again, sir? Can you see this?
Yes.
Uh, and then she asked for money and supplies, and then the money is for daycare. Your response for is you use that for whatever you need. You changed that when you decided to do the court way. That's all I can give because I need to pay a lawyer. Is that correct?
Yes.
And that was in August that you stated that you needed to find a lawyer for a lawsuit, correct?
Yes.
All right. So you admit directly to the mother that you received some notice of service. Those were your words in June. And then you followed up with another text message saying that you needed to save money to get a lawyer to help pay because you couldn't do this whole child support. Is that correct?
I couldn't afford it.
So you couldn't afford a lawyer, but you could afford one after you had noticed that you're going to be paying $850 a month in child support. Is that your testimony today?
My parents are the ones that are helping me out with a lot of it.
Okay, so why couldn't your parents help you out in August when you knew that you needed to pay for a lawyer?
I didn't know in August like that. The only thing I got in the mail was that one letter. I
I
didn't.
understand your testimony, but if we're reviewing the messages between you and the mother, you're stating unequivocally that you got served apparently, and I need to save money for a lawyer. Is that correct?
Argumentative, Your Honor.
Sustain.
All right. So you understood that you could file an answer without a lawyer. Is that correct?
Say that again.
You understand that you could represent yourself and file a general denial in this matter, correct?
Yes.
But you chose not to file an answer. Is that correct?
Are you? I don't. I'm not getting this question because the only thing that I knew about was that one letter.
Then why did you message the mother of the children in June and August specifically about needing to hire an attorney as well as talking about getting served?
Objection repetitive. Asked and answered, Your Honor.
He's response.
I'm sorry. Overruled. That was a different question.
It was the same question, just asked in a different way.
Sir, you may answer the question.
And my answer is like the only thing I knew about was the one letter in the mail, and that's what I was going by.
Okay. And you never corresponded with the court, sending any letters or emails or even calling the court?
No,
You never asked for an extension or responded to any kind of court by going to do any research yourself?
no, because it wasn't like an appeal. It was like a dismissal thing letter.
Okay. Now, did you have any physical ailments or any mental issues over the last 9 months that would prevent you
No,
from answering?
no,
Okay. So you weren't physically or mentally incapable of responding to the service done on you, correct?
no.
Objection asked. That's a mischaracterization of the evidence, Your Honor.
Sustain as to ask and answer.
Okay. And this was your choice to avoid following through in this matter, is that correct?
Following through or what matter?
This case, this is not the first time that we've filed a lawsuit against you, is that correct, Mr. Alvarado?
With my firstborn?
Yes.
Yes.
So
And
you're familiar with the process, hiring an attorney, going to court, and
yes,
everything else. And so after you had reconciled with Ms. Ayala and we had dismissed the first lawsuit, you understood the nature of going to court and where it was?
yes,
Okay.
yes.
All right. I passed the witness, Your Honor.
All right. Redirect.
Briefly, Your Honor. How much time do I have, Judge?
You have 5 minutes, 5 minutes and 36 seconds. Attorney Pedicini, you have 6 minutes and 27 seconds.
Thank you, Your Honor. When you say that you know the process, correct?
Yes, I do.
Okay, and once you are served, you understand that the time clock begins, correct?
Yes.
And did you ever think that you'd been served?
No.
Did you ever have any
I
reason?
was never like actually served. Like I didn't know anything about it.
Okay. Pass witness.
All right. Anything further of this witness?
Yes, real quick. And that 195 Castle Ridge is where your parents reside, correct?
Yes.
And your mom has lived there for ever, basically, more than 5 years.
Yes.
And she was the one, presumably, that answered the door when the service came out to visit.
Mm-hmm.
Now,
Hold on 1 second. Sir, you have to answer out for the record.
Oh, yes.
Okay, thank you.
and you understand that in our application for a motion for substitute service that they have put 6 different notes around that door illustrating that there was a service necessary and that there was a case pending.
Yes, but I wasn't there at the time, so
So you had never heard anything from anyone at the house, your mom or any siblings or cousins?
no.
Okay. And you were never over there in April?
No. Well, I was like on the weekends, only when I had my kids
Okay, but you didn't have a job and you were just staying where then during that time in
with my
April?
sister.
Okay. Now, you hired attorney, Mr. Griffin, in regards to your ability to do a meritorious offense. Is that correct? That you'd like to have this case reopened based on the possibility that you would have a different outcome?
Yes.
Now, the children reside with Ms. Ayala, is that correct?
Yes.
She makes the decisions on their education. She takes them typically to the doctor's office.
Yes.
You would agree that she is basically the primary decision maker of these children?
As far as what the paperwork says, yes.
And previous to the fire paperwork, I mean, did you look to enroll these two children?
She has them all the time. She never gave me the opportunity to.
Okay. All right. I pass the witness.
All right. Okay, Attorney Griffin, you may call your next witness.
We rest, Your Honor.
Okay, Attorney Pedicini.
Call Ms. Ayala.
All right, you may proceed.
Good morning, Ms. Ayala. You're the mother of the two children subject to the suit, correct?
Yes, sir.
And Fabian is the father?
Yes, sir.
And when did you all break up or move apart?
We moved out of the rent house September of 2024.
Okay.
September
And
23rd was the last day.
when did he go live with his parents?
That day, the September 23rd, he moved
And
everything to his mom's.
how do you know that?
We would go over there on weekends, and the boys would go over there and they would spend the night with him.
And you'd physically go inside the house?
Yes.
And were his belongings in the house?
Yes.
Was his bed in the house?
Yes.
And that was from September 2024 all the way up till today, to your knowledge?
Correct.
And has he moved out any time in between to go any other residences?
He's never told me.
Objection, personal knowledge on that question.
And
What's the legal objection, counsel?
Objection, failure to lay a predicate. She has no personal knowledge of being with him. May I take her on board, Dyer?
Yes, you may.
Ms. Ayala, were you with Fabian?
In September?
No, were you with him like after he moved out?
Yes. Whenever we broke up, it was in November.
Okay. When you guys broke up and he moved out, were you with him 24/7?
No, we
You
would
don't
go
know-
over there on weekends.
You don't know where he was the other times other than when you saw him on the weekends, correct?
Correct.
And so you don't know where he was living primarily, do you, during that
No.
time? Okay, pass witness.
All right, counsel, would you like to renew your objection?
Yes, she has no personal knowledge of where he lives. So
Okay, sustain as the speculation.
all right, I'm gonna go in. So you would take the two boys over to Fabian's house approximately every other weekend, or how many times during a month?
Whenever we were together, it was every weekend. Whenever we weren't together, whenever we broke up, it was every other weekend.
And so you've gone to this 195 Castle Ridge house every other weekend for the last year approximately?
Whenever I drop off the boys,
Yes.
well, he comes to pick up the boys from the house.
Okay.
But
And when was the last time you went over to that house to pick up the boys or be inside?
I want to say not too long ago, my son had strep and he took him to the doctor, so I went to go pick him up.
Okay. Did you go inside the residence?
No, I picked him up from outside.
Okay.
The last time I was inside the house was maybe the last October of 2024.
Okay. Now, you had text message back and forth that we've included exhibits with Fabian, correct?
Correct.
And those include direct messages that he acknowledged being served and needing money to pay for an attorney. Is that correct?
Correct.
How has he told you during this pendency of the case before it was resolved in October that he knew that there was a legal case that you had brought against him for child support and custody?
I'm sorry, I don't.
How did you know, or how did he tell you that he knew that there was a legal case that you had brought up regarding child support and custody?
So he knew about it Sunday, October 13th. He stated to me in a text that we will wait until court, everything will be settled. And then January 20th at 5:25, that's when he sent the message saying he had already got served.
When did he send the message that he had gotten served?
June 20th at 5:25.
Okay. And did you talk about this case at all with him in regards of resolving it or having him sign a waiver or anything?
No, because we really don't talk.
Okay. And did you bring up the child, or did you bring up the cost of the lawyer at the other text message in August?
In August, he just stated that he needed to pay a lawyer.
And did he say why or what the
No.
cause was for that text message?
He just needed to know, that's all. He just needed to pay a lawyer.
And that's when you were asking for child support, correct? Or money to help for the boys?
Correct.
And do you believe that he had actual knowledge of this lawsuit?
Yes.
And were there anything other than those two text messages where he specifically talked about the lawsuit that you believe illustrates to the court today that he had knowledge that there was a lawsuit against him?
That paper he's talking about, he showed up to the house on April 10th whenever he was picking up the boys, and he asked me, "What is this paper?" It was the motion of dismissal. He said, "What is this paper?" I said, "I don't know." And he said, "Are you putting me on child support?" I said, "Yes." And then after that, he said, "Okay." And he just took off with the boys.
Okay. So he was aware of a pending lawsuit, and then he also was aware that he was served, correct?
Correct.
Objection, speculation.
He admitted it
No, he didn't.
on a text
Uh,
message.
So, I'm going to, overrule the objection as to speculation. And counsel, you just ran out of time. Attorney
All right.
Griffin?
Thank you, Your Honor. Ms. Ayala, you understand that filing a suit and having knowledge that a lawsuit has been filed and actually being served with that lawsuit are two different things, correct?
I'm going to object for a legal conclusion.
Sustain, rephrase.
Is it possible that Fabian knew that you had filed a lawsuit against him, but that he didn't know that he had actually been legally served with that lawsuit?
I'm going to object to speculation and legal conclusion.
Sustain is to drawing a legal conclusion.
Okay, you don't know whether he knew that he had actually been formally served with that lawsuit, do you?
I mean, he knew in text messages.
Okay, you heard his explanation that he said that he had gotten a letter and he did not know what that letter was. And that's what he was referring to. He explained that, did he not?
Correct. But on June 20th, he
Okay.
also told me he got served.
Sustain after correct.
You and he, did you discuss at all the terms of the child custody issues from the time that you filed your lawsuit until the time that you took the default against him?
We've talked before that he would get the boys every other weekend.
Okay, so you had been discussing settling your case, correct?
Correct.
And you didn't tell him that you were going to go take a default, did you?
He asked if I was gonna take him for child support.
You didn't say that you were going to go get a default judgment against him on October 17th, did you?
I'm going to object to relevance.
Counsel, what's the relevance?
Just that he didn't have knowledge of the actions that she was taking. He didn't know that he had an impending threat of being defaulted.
Sustain.
Pass witness.
Okay. Attorney Pedicini is out of town. I have a question, for Mr. Alvarado. Are you working currently?
Right now, no, I've been helping my cousin out with his trash business that he does.
When was the last time you were employed?
By an actual employee, I'm not sure. I want to say UPS was the last time I was employed
How do you pay your bills?
with the little money that I get in my parents.
All right. I was looking through the exhibits that were sent by you, Attorney Pedicini. It looks like you were giving her money for daycare
Yes,
as well as child support.
yes.
Attorney Pedicini, how did you come up with the $845 amount for his child support?
My client, during testimony at that hearing, put on direct knowledge of him receiving money directly from being paid out. She said about $1,000 a week is what she remembered when they were last together. And that's what she believed he currently was making at the time that we had finished this suit.
And that date I got September 23rd of what year?
For the default was in October of last year, but the testimony was just from my client as to talking about money, the way that she'd been paid child support and everything over the last year, that those were the standard figures that she believed that he was still making for child support.
Okay. Was the OAG ever noticed to well, let me back up. He's paying cash medical, so that means that these children are on government assistance, correct?
Yes, and we had sent over to 413 CSD notice of the hearing and everything else, but they didn't.
They didn't intervene?
No, ma'am.
Okay. So what the court is going to do, Attorney Pedicini, how much did you incur on the day that you did the default judgment?
For my work for an hour, it would be $350 at the time, and then for the actual subservice and everything else, would be another $250, so maybe about $600.
All right. So this is what the court is going to do. Because looking at the evidence, his work history and what he's talked about here today, along with the child support amount, that $845 seems excessive based on what's been given her monthly. Because what he's been giving her monthly, from what I saw, child just $180. And then he was also paying daycare, and then he was also paying what do you call it, the extracurricular activities. It still didn't equate to $845. So before the court, because you all are here today, before the court makes that what his child support is going to be moving forward, I think the Attorney General needs to intervene, and there needs to be some sort of discovery conducted on his actual net resources. So the court is going to set aside the judgment only for the narrow issue of child support and medical support. Because the cash medical, that even may change. We don't know, because we didn't get the figures directly from the Attorney General. And the court thinks that would be in the best interest of the children, to see what his child support should actually be. So I am going to set aside the judgment only for the child support. Everything else stays intact.
Okay, may I ask just one question, Your Honor?
Yes.
The joint managing conservatorship is a joint managing conservatorship as it is set out in name only,
Correct.
which is, I don't believe that if we have a full hearing on that, that would be what the court would order. I would ask that you would open that up to at least allow him a say in the key management rights of a child's life. I mean,
well, counsel, in fairness, I haven't heard any evidence from you asking your client any questions to make the court believe that that should be changed. I didn't hear anything about who does the primary rearing of the child besides, I mean, really anything. Like, does dad take the kids to school? Has he been tasked with taking them to the doctor's appointments. I didn't get any of that testimony here today. I can only make rulings and grant issues based on the testimony that I'm providing. And the only testimony that I've been providing in conjunction with the exhibits would be his child support. So I have in front of me an order. I'm going to tweak that order, and then I will send that back to you all today. And I did forget that the $600 attorney's fees, Mr. Alvarado, since you did offer, if I were to open this case back up, that you would pay those, I am going to order that you pay that $600. How long do you need to pay the attorney's fees?
I could talk to my parents and see if they could help me with that.
Okay, so I'm doing the order today. I can put it in the order. I can give you 30 days, 45 days. Which one?
I'll take the 45-day just to be safe.
Okay. And Attorney Pedicini, if I were to do what do you call that? If I were to do the Google search and pull you up on the State Bar website, would that be the address that you would want the attorney's fees to be sent to?
Yes, it should be the
Okay.
accurate one.
Okay, I will do that, and I will get you all an order out, and then my coordinator will be in touch with a date that you all can have the trial specifically on child support. You may go to mediation is an option, right? In this particular situation, I don't require mediation for a narrow issue like child support, but if you all choose to go to mediation, you can, and agreement on what that amount should be. But otherwise, you all will get a trial date from my coordinator.
Thank you, Judge.
All right, thank you.
Thank you all. Your excuse.
And Judge, just to reiterate something, I know that you said you were going to get that signed today, but
Yes.
plenary power runs tomorrow. So just to apprise the court.
Yes, so I get it signed today.
Great. Thank you. Appreciate it.
This case doesn't begin with a heated custody battle. It begins with one critical question that could erase an entire court judgment. Did a father intentionally ignore the lawsuit, or was he never properly served in the first place? What starts as a simple motion to set aside a default judgment quickly turns into a tense courtroom battle over notice, fairness, and whether a father deserves a second chance to defend his parental rights. At the center of the case is Fabian Alvarado, who asks the judge to throw out a default order that strips him of nearly every major parental decision-making right, while ordering him to pay $845 per month in child support and more than $37,000 in cash medical support. Fabian insists he never intentionally ignored the lawsuit. He tells the court that he never received the legal papers allegedly left at his parents' front door because he mainly entered the home through the back entrance and was often staying with his sister at the time. According to him, the first time he truly realized a final judgment had already been entered was when the children's mother handed him the signed court order after the case was over. He immediately began searching for an attorney because he believed he had never been properly served and had been denied the opportunity to defend himself. Fabian also tells the judge that the existing order gives him almost no meaningful parental rights, not over medical decisions, education, psychological treatment, or even other major issues affecting his children's lives, and says he simply wants the chance to present his side before such life-changing decisions become permanent. But the children's mother, Ashley Ayala, presents a very different story. Through her attorney, she argues that Fabian absolutely knew about the lawsuit months before the default hearing. The most damaging evidence comes in the form of text messages where Fabian himself allegedly tells Ashley that he had already got served and later admits he needs to save money to hire a lawyer because of the child support case. The mother argues that these messages prove Fabian knew exactly what was happening but simply chose not to respond until after the court entered an order he didn't like. She also explains that process servers attempted to personally serve Fabian multiple times before obtaining court approval for substitute service after 6 unsuccessful attempts. According to Ashley, Fabian wasn't confused. He was simply avoiding the lawsuit until it was too late. As both sides continue presenting testimony, the hearing becomes less about whether service technically occurred and more about whether Fabian truly had actual knowledge of the lawsuit. Under questioning, Fabian admits sending the text messages but explains he believed they referred only to a letter he had received mentioning child support rather than formal legal service. He repeatedly insists that nobody ever personally served him. No family member told him papers had been left at the house, and he never intentionally ignored the court. The judge carefully listens as both attorneys aggressively challenge each witness, with the mother's lawyer pointing out Fabian's own admissions about needing money for a lawyer, while Fabian's attorney argues that knowing someone filed a lawsuit is completely different from being legally served with one. Then the hearing takes an unexpected turn. Instead of focusing only on service, the judge begins asking detailed questions about Fabian's employment, income, and financial history. She notices that although the default order requires nearly $845 per month in child support, the evidence presented suggests Fabian had been making much smaller payments while also helping with daycare expenses and extracurricular activities. The judge openly questions whether the child support calculation was ever based on verified income at all, especially since the Attorney General's office never intervened to establish his actual financial resources. At that moment, the case shifts from procedural arguments to the best interests of the children. Rather than completely overturning the default judgment or leaving it untouched, the judge reaches a compromise. She refuses to reopen the entire custody case, explaining that Fabian failed to present enough evidence showing why the conservatorship provisions should change. However, she does agree that the child support and cash medical support deserve another look because the financial evidence appears incomplete. The judge sets aside only the child support and medical support portions of the default judgment, leaving every other custody provision in place while ordering a new hearing after proper financial discovery is completed. She also requires Fabian to reimburse the mother's attorney $600 for the costs of the original default hearing because he had previously agreed to pay those expenses if the judgment were reopened. By the end of the hearing, neither side walks away with a complete victory. The mother keeps the custody order intact, while the father earns another opportunity to prove what his child support obligation should actually be. In the end, this case becomes a powerful reminder that even when a default judgment appears final, one question about fairness, notice, or financial accuracy can completely change the outcome.